Good evening, everyone. Welcome to IQI Canada Facebook Live session. Today's topic, we are going to talk about the assignment sales. For with me, I have Mr. Gujral, who is a barrister and solicitor based in Mississauga, Canada. Welcome, Mr. Gujral.
Thank you, Mr. Zikar. Thanks for having me.
Thank you for taking the time to come and talk to us today about the assignment sales. So, just before we start, I would like to, for the benefit of the audience who are watching this program, is that this is not a legal advice. Anybody who's looking to a specific legal advice on any matter, including the assignment sale, should speak to the legal counsel. Today, we are going to share more general knowledge about assignment sales and what are the things one should consider when they are when they are looking into the assignment sale or purchase of the property. So, Mr. Gujral, it would be helpful to know if you begin with what is assignment sale means to begin with.
Firstly, adding off where you're leaving with regard to this is an informational session only, right? This is not a legal advice. Now, coming to your question with regard to assignment sale, it is basically whereby the purchaser of a property agrees before the actual purchase to sell his right to purchase. To put it that way, basically, the seller, the purchaser who is selling it, he becomes a signer, and person who is buying from him becomes assignee. So when we are discussing, it will be regard to interchangeable terms: assigner, assignee, purchaser, and seller.
Okay, so does it mean that it's only happens when the property is still under construction, or it also happen in the ready properties?
It can also happen, but usually happens in pre-construction properties
Mm.
because there's a time between when you enter into an agreement of purchase and sale and when you actually get the possession, when you actually perform a purchase. So during the interim, lot of things can happen for different reasons. Assignment can take place. Whereas in regular resale houses, it can take place, but there's a very short window between the agreement and the closing.
So what if I understand correctly, correct me if I'm wrong, that what you're saying that assignment sales that typically happen when somebody buys and book up any pre-construction house or condo or any property which is still under construction and is going to be getting a possession time in 3 to 4 months, uh, or before or closing or like few months before the closing or the possession, you can basically assign the your right to sell or purchase to a new buyer.
Yes, that's pretty much it. But it can be a different, like whether some builders these days giving 3 years closing time or 4 years, sometimes 1 year. So it depends different for different reasons. That can happen.
Okay. So, what are the scenarios where it can happen in the ready properties? Because normally when you buy a ready property, how do you think any scenario where pre assignment happens?
There can be various reasons why the closing date are kind of put in not a regular window of 60 to 90 days, say 6 months, 1 year, because sometimes you're selling the estate property, like person whose property was in his name, he expired for, and his legal heirs are trying to get a certificate to sell that property. So there's a usually long window. This closing happens in 6 months, 1 year, and there's still gap. When the property
Mm.
price is rising, so you can buy for say X amount, and the next plus something, you can put it further down,
I just
provided
would
you
like
agree.
to say hello to Yusuf who has just joined us. If you anybody's watching our program, if you have any questions, Mr. Gujral, regarding assignment sales, please feel free to type in the comment section, and we'll be happy to provide response to that. Um, so so understood. In terms of the why would somebody want to like do the assignment sale? Why there is a need to do assignment sale and purchase?
Sometimes what happens is when the builder is coming up with the new properties, he is putting a value, which usually sometimes say is the initial value before he starts his project. During the project, price increases. Or some people want to have an as an investment, right? Today they put in some investment, some amount, 20,000, 50,000, something, and get booked a property which they know over the period of 1 year, 2 years before they get the possession or closing, they're going to have increase in price. So they want to, for various reasons, either to get the profit or they're unable to close for any reasons. So where they'll comfortable to selling it out to someone else.
So effectively before the taking the possession, you can sell the right to us, or you can assign the right to sell of that particular property to a new buyer, and it's called the buyer who's going to buy it and then ultimately going to take a possession of the property.
It will depend upon the agreement of purchase and sale entered initially with the builder, because he builder has to permit you for assignment. In some cases, builder does not permit. In some cases, they charge a fee. Sometimes which can be percentage, sometimes X amount, something free, sometimes depending upon. So you
So
have to review the agreement before
So
you.
effectively, when you do the normal buying, selling of a house, you know the property is ready. You go and view that, right? And you're different type of agreement, different type of conditions you put in it. So what are the things? What are the few key factors when we as a realtor negotiating the assignment sales? What sort of things we should consider? I think the lawyer work is more than the normal sale, I guess.
Exactly. In these scenarios, there are a couple of two things. One is when you are buying a property from the builder, you enter into an agreement with a view not to buy it but to sign it. Then you can negotiate something with the builder and put an assignment clause, fees, without fees, whatever you want to. But once that agreement is entered, it is final. Then second stage, when you're entering into the assignee can't do much except he's taking over whatever has been agreed upon. So there's very limited moving space in terms for the assignee.
So what you're saying that in terms of the, so when you're somebody looking to sell the assignment sales, I think the key factors or key document to look is the agreement of purchase sale signed by the current owner and the builder, right? So
That's right.
what are the things one should look into that? What advice you provide, or what sort of key points you look into that when you look at an assignment sale?
The first is whether or not the assignment is allowed. Second
Okay.
is what is the cost? What are the consequences? Usually builder puts in some amount that if you want to assign it, you have to pay my lawyer's fees, you have to put the whatever amount he's incurring. It can be X amount, it can be percentage, or whatever amount has been agreed upon.
So effectively, what you're saying that whenever realtor have some property to sale on assignment, right? So they have to first consider whether the builder in agreement to purchase it allows a current owner to sell it on assignment. The first thing that's the first thing to see.
Exactly. Yes.
Assuming is allowed. If it's not allowed, you can't do anything. If it's allowed, what we are supposed to do?
If it is allowed, then you need to see what are the clauses, what is the cost involved. Because you need to advise the assignee who's purchasing that what he is getting into.
Hmm. So,
So
but is there a fees involved? What sort of fees you're talking about? Are you talking about thousands or hundred thousand fees, or just a nominal fee?
one, as far as the builder's lawyer fees you have to pay, which is not usually much, it is the regular fees. But what is builder charging you for assignment? That can depend upon anything between 5,000, 10,000, or some percentage of the cost, which
And I
is
think we and our experience see that some of the builder allows the free assignment. Only have to pay the lawyer fees. Always have to pay the lawyer fees. Lawyer fees not only the builder lawyer fee, but also the lawyer of the buyer and seller. But at the
it
same
depends.
time, depends. It depends.
Yeah.
But let's suppose if there's no fees, no fee. But if there's the builder fee, who's supposed to pay the fees? The person who's selling, who's the current owner, or the
Yes,
person who's
the
buying?
assigner is paying.
Means the person who's the current owner, who is the seller in this case. Okay, so that's answer the Yusuf asked this question. That answer the question who pays the assignment fee. The Yusuf, I think you got the answer that basically the current owner who is a seller of the assignment property is going to pay the fees, whatever is listed in the agreement of purchase or sale. So we have another question from Zaman who joined us also. Should the developer demand deposit from the owner during the assignment process until the transaction is completed?
Yes, this is a very interesting question because this comes up many times.
Hmm.
In the terms of the agreement of purchase and sale, when you are buying a property from the builder, under the assignment clause, he has put in certain conditions. I've seen come across last few months that builder puts in a condition that at least 25% has to be paid before assignment. So what happens is when you approach a builder saying I want to sign it, he's going to ask you the deposit.
Oh,
So
this is on top of the current payment terms, the current one already paid, you mean to say?
yes.
Oh, okay. So this is
So
already listed in APS. It's very important
this is
for
yes.
to us to read the APS. So how, because I think normally lawyers' uh, effort involved is more because we have to go through all those terms and conditions to make sure that uh, these things are covered.
These things are covered, and also the assignee knows what he's getting into.
Okay, so man, your answer to the question is yes. It's all it depends on the what is listed in agreement of purchase or sale, as Mr. Gujral. If there is certain clause which require you to pay the deposit, you have to pay the deposit. But again, we cannot say anything specific to any case. You have to look at each and every APS. Thank you, Mr. Gujral. I have another question from you. So, how many lawyers are involved in the assignment sale process?
One would be the lawyer for the builder, what we call vendor. Second lawyer would be from the assigner who is selling. Third lawyer would be who is acting for the assignee, who's purchasing. So once the assignee signer is done, then the deal assignee deals with the vendor, the builder. So basically three
Okay,
lawyers.
so if it is three lawyers, typically you have two lawyers. In this Simon case, you're saying it's three lawyers, which is additional lawyers from the builder side because that's the one who's going to give an approval.
No, that's not additional. That's already there. It is just the between the assignee and the signer, they get one more lawyer. Builder one you
No,
have to deal
okay.
with anyways.
What I mean to say, the normal purchase and sale, you only have two lawyers. In this assignment, you always have a third lawyer, which is the lawyer from the builder side, which is not normally involved when you're buying a ready property.
Yeah.
Okay. So what are the restrictions? What are the restrictions or terms on the APS which one should, other than the builder approval and the fees, and whether the assignment is allowed or not? What about any marketing? Because when you want to do this assignment sales, in a typical ready property, you can do MLS listing, you can do other things. So does an MLS listing allowed in assignment sales for the seller to do it?
Mostly no. Builders specifically state that you will not be listing. You will not be listing anywhere. There is a restriction on marketing with regard to assignment. Sometimes, not always, sometimes the clause is there that you have to seek permission before listing, which is very rare. Mostly it is no. You have to be using alternative methods for marketing or selling or whatever. I think you are in a better position to answer this question as
Yeah,
a
and
brokerage.
yeah, I think our experience we have seen recently. We recently closed one assignment sale along with you, Mr. Guzar, and you know that we didn't do list in MLS. What we did was that we did marketing through different mediums, social media channels, as well as the email alert we sent to our investors and our contacts to see we can have finally buyers. Mostly nowadays, MLS is not being used for assignment sales because, as usually is said, that APS most of the APS doesn't allow. But of course, APS agreement of purchase sale is a document which is going to drive what is allowed and what is not allowed. In terms of the closing, is it how the closing? What is the closing involved in assignment sales? When you say closing of
But before I go to this, answer this question, I want to go back to your question. Not only there's a restriction not to list it, but sometimes there is a specific clause in the agreement of purchase and sale stating that if you list it, you breach the agreement and we forfeit your deposits
oh,
or cancel
interesting.
the contract. So you
Yes.
have to be very mindful and careful what is written in the agreement of purchase and sale before even thinking of proceeding forward with regard to assignment.
I think that's why the lawyer's involvement in assignment sales comes early in the process, even if you start doing the marketing, because the realtor can read the agreement, but it's also important for the seller, who's the current owner, and the realtor to understand what are the do's and don'ts as listed in the agreement purchase sale, because you may think it's a standard agreement, but it's very important to understand what is specifically written in your specific APS. So thank you, Mr. Gujral, for
Yeah,
highlighting that.
yeah. Now coming to your answer with regard to what it entails two stages. One stage is assuming that you have entered into an agreement with the builder, whom we call vendor. and you have purchased the right to close the property, to buy that property. Understand? You have paid some deposit, not everything, right?
Mhm.
Then before you get actual possession or actually close, you enter, you find someone to assign that uh, purchase, your right. Basically, it is you are selling your right to buy a property. That's what the assignment is. So part two starts when you have someone you can assign it to. So agreement is entered between the assigner who is selling and assignee who is purchasing.
Mhm.
Once they enter into an agreement for whatever terms, then the second stage is that agreement is not complete until builder agrees to it. So part two of this transaction would be getting back to the builder's lawyer saying, we're going to sign it. These are terms, and now builder lawyer has to prepare documents transferring the right from assigner to assignee. So that's two-part closing in terms of the assignment.
Okay.
Once
So,
the builder is putting everything, documents in order, you sign everything, closes, then it is between the assignee and the builder.
so effectively, if I take an example that if I have right now I own a property which is under construction, right, and is going and expected to complete it by October of this year, right? So let's suppose I find a buyer somewhere in July, August, right? And so I need to first transfer from my name to the buyer name in the developer books, and then the person who's buying or the pre-assignment or assign that buyer is going to transfer in his name when the developer is going to provide a possession. So that's why there's
Yes,
two-step closing. Okay.
yes, that's right.
Okay, perfect. Now, when this thing happened, let's suppose let's take the example which I just mentioned that I sold the right to that property to person Y, right? And that person Y has and builder approved everything, the assignment fee, the legal fee, everything is paid. Now in developer books, that property is owned by the person Y, right?
No, 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 no. Stop there. Because that property is owned not by Y, but his right to buy that property.
Okay,
His
okay,
owner is still the
understood.
builder,
Makes
unless the
sense.
money is paid and transfer takes place.
Okay, understood. And then at the closing, when the new person who has a right to of that property is going to pay all the payment, and the land, the property will transfer to that person's name, then it becomes the owner. Now, how does the liability? Now, in that process, anything can go wrong, right? I don't go. I
Right.
mean, between the time I assign this property to the new potential new person who bought the right to that property till the closing, to the occupation and closing. Who, help me understand whose liability is there. I mean, what are the liability of each of the party involved in that process?
Both. Now, what normally builder does is he does not let off the assigner
Hmm.
unless the closing actually takes place and everything is good.
Okay.
No, builders do not. If all goes well, nothing happens, right? If something doesn't go well, then the builder goes back to the assigner also. Like he
Original
will,
buyer.
the buyer, yes, the original buyer.
I mean, I
That's
just want to keep it simpler because people get confused with the signers, and I know it's a legal term. I just want to, in my example, that if
no,
I
there are
initially,
couple of purchasers and buyers are confusing, right? Because the person who has purchased the prop from the builder, he becomes the seller,
yes, sir.
and the person who is buying it from the seller becomes a purchaser. So
Okay.
when we are talking about purchaser and
Original.
seller, it is confusing. That's
So
why I
I
was
said,
trying
okay,
to.
let me say original person who booked the unit, I
Okay,
guess.
let's do it that way. The original purchaser as well as the new purchaser.
Okay.
I think that will simplify the understanding.
So the current purchaser who may not, if even if he have the assignment transferred to his name by the original purchaser, and if he can't close it, the original purchaser is still responsible to close that unit, correct? From developer
Uh,
perspective.
what usually happens is there is substantial rise in the cost.
Hmm.
So only when the builder suffers a loss, he goes after the
Original.
uh, original. Otherwise, they forfeit the amount and they sell it to new person,
Oh,
in which
okay.
they make profits, right?
Okay, interesting. So
So
it's
that
in the
way,
increasing market, the developer will not go back to the original purchaser. You just go forfeit it, and
yes,
effectively the new buyer will lose the deposit paid and also the premium paid to the original purchaser. Yes.
exactly.
Interesting. Interesting. Does there any insurance policy need to be bought? Because I know when we do the ready property buying selling, buyer normally buys the title insurance. Is there any sort of insurance to be taken in that in this assignment sale or purchase?
I said there's two part of transaction. The first part is with assignee and assigner.
Hmm.
Title insurance not required because title insurance is associated with a title to a property, and this is just a right.
Okay.
You won't be able to get it. Now, second stage is once the assignment has been entered, when the new purchaser is buying a property, then it is required because he's getting title to a property which builder is selling, right?
So even
At
with
that,
a new property, we must buy the title insurance, correct?
absolutely.
Because normally for the older properties, you don't know what happened since the property was built in and then how many owners were there. But if you're buying a brand new property from the developer, the title insurance still needs to be procured.
We have a very broad view of saying title insurance insures the title, but it is much more than that.
Hmm.
Like last time we discussed, we need a
Yes.
whole discussion on title insurance, right? What it covers and what it doesn't cover. It is pretty broad.
Yeah, I think we've had a separate session specifically going in detail about the title insurance
Yeah.
because it's very relevant for anybody who's buying the home. It's not for sellers; it's mostly for the buyers, and we will discuss in more details what are the benefits of buying a title insurance and how does it
Yeah.
help for the buyers to make sure that it covers the risk involved in the property title and a few other things.
At least I
Uh,
would recommend, I mean, it's a one-time cost, not a large amount, but it kind of gives peace of mind for a number of situations.
Okay. So in terms of, so we talk a lot about today assignment about from the seller perspective. What are the things the buyer needs to consider when you talk about the assignment if they're buying a right to that property?
The buyer, the new purchaser, yes, new
Yes.
purchaser has to be very carefully reading the agreement of purchase and sale because he needs to know what he's getting into, how much it is going to cost you, how is there any restriction with regard to the use of property, what is involved around the property, what is the development around, like the number of things that has to be looked into very carefully. And there's nothing, one thing I can suggest here that you should be aware of. There's so many things you have to be very careful about.
So
So
effectively, because when you're buying a ready property, mostly the lawyer get involved at the time of closing. But I think in when you're doing the sale or the purchase of the pre on assignment, whether it's the pre-construction or ready property, when you're doing the assignment, purchase and sale, it's important to involve your legal counsel ahead of time to make sure that all these things are properly reviewed and identified, so that when you know what you're buying and you make an informed decision.
from
Uh,
point of view of a new purchaser, it is highly recommended as soon as possible, even before he pays up as a fee for entering into an agreement, so that he knows exactly what he's getting into.
yeah,
He
because
can't change anything. Can't change
nowadays when we
anything.
see that because of the sellers' demand, the builders are selling. You have very too many people trying to buy too less units. Like for 100 units, there are 1,000 buyers are standing, and I think developers are not giving enough time. Some of the developers are giving you cooling off period where you can get lawyers to review. But I think the most of the time they don't even provide that time. So, in that view, what do you suggest? How do the buyers basically go about that in terms of the legal review of the document?
It's not an easy answer. Like you're blind, going into a blind zone. You don't know what you might incur. It's
Yeah.
always advisable to know what you're getting into. But if you don't know, you take whatever comes up, right?
I think what we advise to our client is that they must get a lawyer to review it, and if you think that there are certain terms which are something is not in favor or they're not in line with what you should be getting into, either you don't buy the unit or try to negotiate this with the developer. If developer agrees to change, it's fine. If doesn't, then it's better not to buy. Take a risk. At the end of the day, is the person who's investing the money's decision. Our job, ours and your job, is to advise them what is best for them.
I think you summed up very precisely.
No, I think we're working with you. You are such a person that you learn a lot of things from you last. more than a year we have been working with you, and then you provide a lot of information. You help us learn and understand a lot of terms, and I really appreciate because, and it's all about what the objective of this program also with your help is to spread the knowledge and share the knowledge so people who are watching this can help them understand better. But of course, at the end of the day, as you mentioned, it's not a legal advice. You have to take a specific legal advice in specific circumstances.
Because every agreement is different, every circumstances are different. So this is just informational purposes. So you should
Yeah.
know more, but this don't replace it by calling up a lawyer. That's not a replacement.
So if you sum up the today discussion is that what I gather is that important things to get a lawyer to review the APS,
Right.
which will help you drive and determine the steps needs to be taken in any sale and purchase for assignment.
Yes, exactly.
Thank you, Mr. Gujral, for your time today, and really appreciate. Please, if you have any, I think we have any questions. We have any further questions? No, thank you, Yusuf. Thank you, Zaman. Thank you for joining us today. Anybody who's watching this program, whether after not live, also, if you have any questions about assignment sales for us or Mr. Gujral, you can get in touch with us. You have a number. Mr. Gujral will also have a Facebook page and his contact details. Thank you, Mr. Gujral, again for taking the time and enjoy your evening.
Thank you, Mr. Zikar and Team IQI for making this happen. I hope people who are watching it going to take some advantage as in knowing more about assignment when they get into an assignment. It will help them. Thanks again.
Thank you. Good night, everyone.
Good night.